Ladies and gentlemen, my name is Elder Christopher Lugo, and today I would like to make a dispensation in light of the law that is often, wielded as a sword of justice, but at the same time as a chain of containment, where the trial itself becomes the punishment and the verdict an afterthought. We remember that in 2024, Dr. Kiiza besigye, a prominent Ugandan opposition leader, was actually abducted from Nairobi, Kenya, and subsequently charged before the General Court Martial in Kampala with offences including illegal possession of firearms and soliciting military support to undermine what you would say internal security. And the decision to prosecute besigye in the military court was not with significant legal challenges. So on January 31st, 2025, the Supreme Court of Uganda referred that trying civilians in military courts is unconstitutional and mandating that all such cases be transferred to civilian judicial systems. Now, following the ruling, the jurisdiction over besigye case was actually transferred to civilian court, where he now faces treason charges. And this is a shift in terms of, what underscores the legal principle that civilians should actually be tried in civilian courts in light of, adhering or ensuring adherence to constitutional rights and fair trial standards. So the initial charges may have been influenced by what? By the nature of allegations that are in the context of his arrest, but the Supreme Court also reinforced the necessity of proper jurisdiction application. Now, regarding legal principles, in light of what we call a holding charge, we could argue that in this instance, whatever charge was imputed upon him would have been held, argued as a holding charge, referring to a provision or what? Accusation used to detain an individual while further investigating, investigations of probably taking conduct. And the initial charges in the military court should actually be perceived as a holding charge, facilitating detention during ongoing inquiries. Now, the concept of cognate and minor also comes into play, what we call cognate and minor offenses, which allows the court to actually convict an individual of a lesser offense in the event that the original one does not substantiate enough evidence in terms of severity or in terms of fixing this particular individual. So there are substantial issues that we would like to argue in light of what transpired. In summary, we could say that the progression of besigye's case from military to civilian court highlights critical issues in terms of jurisdiction, in terms of constitutional right, and the application of legal principles in terms of ensuring justice and the adherence of rule of law. Now, the question is, why was there a shift between the military court and the civilian courts? And I think that is something that I have learned to explain over a period of time. But for starters, I would argue and say that Dr. Kiiza besigye's case initially fell under the General Court Martial because of charges related to illegal possession of firearms and soliciting military support to undermine national security. However, the case was actually transferred in a civilian court where he actually now faces treason charges. So one would wonder and say, okay, when they're in court martial, they had a number of cases, including judicially, and now we are in civilian court and we're only seeing treason. Why is that happening? The reason for the shift could be any of the following, and this is something that I would like to argue. Number one, in terms of jurisdictional challenges, there could have been jurisdictional challenges that have caused that kind of change of offenses in that sense. The Supreme Court of Uganda ruled that trying civilians in military courts is unconstitutional, and this reinforced the principle that civilians must actually be tried in civilian courts unless they are active military personnel at the time of the alleged crime. And that is fundamentally important in terms of what the Supreme Court made, and that's where we are now seeing in step two, in terms of the understanding now what were the nature of the charges. Do this nature of the charges fall within that mandate that the Supreme Court gave? Now, the military court primarily deals with offenses under the UPDF Act, such as illegal possession of military equipment okay? And that is something you must understand again from the word go. But also, you could also argue that, however, treason is a political offense under the Penal Code Act, which falls strictly under the jurisdiction of civilian courts. So we can see that clearly the reason why civilian courts are able to take on the treason case as opposed to treachery is predominantly because treason falls within the civilian courts as well, as I just made that point. Now, once the Supreme Court ruled against civilian trials in a military court, then the state had to reconfigure, the charges and move them to a proper legal forum. And that's what they've been trying to struggle with all around, with the instructions of the powers that be. Now, also another important aspect that you need to comprehend is the aspect of what they call the due process and fair trials. Military courts are often seen as less independent and subject to what? Executive influence. I have made that debate before. So the transfer to the civilian judiciary ensures compliance within constitutional and human rights principles. And that is the argument that we are all saying, and that's what the argument that all international obligations are actually required of us, since we are in most cases signatory to some of these things. Now, there are major and cognate offenses in this case, and that is something you don't understand. You need to understand also, by the way. Yes, and the distinction between the major offenses and cognate related offenses in this case also warrant one way or the other in terms of what cases could be preferred to the against the other. For example, if you're talking about major offense, treason becomes a major offense in spite of the fact that it's before a civilian court. Treason under the penal code is actually a capital offense, and primary charge against besigye becomes treason in this particular concept. So that is something you must understand from the word go. So if found guilty, for example, the penalty could be life imprisonment or even death. So that is something. So it becomes cognate in a sense that it's actually bigger and can be able to swallow up, I'm using that word loosely, these other small cases that ordinarily would actually be befallen besigye. But as I told you, more importantly was simply because the treason case was more found within the civilian court as opposed to the treachery that is probably found within the UPDF, which now the court had actually ruled as null and void. Now, in terms of cognate related offenses, if the court finds insufficient evidence for treason, for example, it could convict him of a lesser offense, such as, for example, sedition or inciting rebellion against government, for example. So they have also captured that, and so that's the reason why they have actually given that particular, offense. And also even misprision of prison, for example, failing to report a treasonous activity, what they call misprision of prison. So all those are substantial things that they could look at in light of, why people are asking themselves, why are we seeing a different a different ball game in terms of these two different courts. And then you could also argue in terms of unlawful assembly, organizing process that may disrupt public order, perhaps. So these are all possibilities, and that's the reason why we have to decipher and place this thing in context. Now, in light of what some people may argue in terms of what they call minor offenses, if treason charges fail, for example, then the state may actually fall back on the cognate offenses to secure a conviction. Yes, and that's the argument of minor and cognate that we should comprehend as well. Now, similarly, in the military court, illegal possession of firearms could actually be an alternative or perhaps even a holding charge while investigations are actually doing what? Continuing. Now, the delay obviously is subject to the fact that the initial investigations were carried out by probably CMI or ISO or ESO for that purpose. On the other hand, civilian charges could have been carried on by way of the DPP and signed by the DPP in terms of the state attorneys or whatever. So in terms, if we reflect on the holding charge, a holding charge is a temporary legal accusation used to keep a subject detained while investigations are actually ongoing. So in Besigye's case, we could argue that the military court charges may have been actually a holding strategy to detain him while authorities build a treason case. And that is something you must understand as well. So even as we are, deliberating about the delays and the struggles, all these are substantially legal gymnastics that are likely to offend people if we don't comprehend what we're talking about. So once civilian courts took over, then the state focused on treason as the main charge, abandoning the military court process. And that is something you must understand. So by way of conclusion, I would urge you and make the following proposition, that in spite of the challenges that we're having today, we should understand that the shift between courts highlights key legal principles in light of constitutional jurisprudence, but also in light of what they call jurisdictional matters in terms of military courts that can't try civilians in that respect. So the legal strategy, therefore, the strategy could be that the state may actually charge someone with a military offense first, holding charge, while preparing a stronger civilian charge in that perspective. I mean, that's food for thought in terms of jurisprudence for this matter. Now, I would also argue in terms of, again, for purposes of emphasis, in terms of what they call cognate offenses as a matter, if the major charge, that is treason, fails, then the court may actually convict on a related minor offense. And that is something I've already made substantially very strongly in this discussion today. So this case, in my opinion, reflects a broader legal and political dynamic surrounding opposition figures in Uganda. And this is something we cannot hide away in light of what we are just discussing. Now whether there are likely chances of success for the treason case against Kiiza besigye, I know this matter is subjudice, but we're just making philosophical and jurisprudential justifications in light of the probabilities of success. Okay, the chances of the state securing a conviction against Dr. Kiiza besigye majorly depend on several legal and political, evidential factors. Yeah, I would argue in terms of substantive strengths and weaknesses, for example. And these are things I want to bring to your attention in light of some of the things that we need to comprehend in terms of the chances of success. Number one, we need to understand that factors that could lead to conviction, as far as the state's case is concerned, could be some of the following in light of the case as we speak today. In terms of the strength of evidence, is there substantive evidence that can actually pin Dr. besigye in terms of the things that we are alleging or they are alleging? If the state, for example, presents a clear evidence that besigye was directly involved in organizing or even supporting unconstitutional actions such as attempting to overthrow a government, then the case could actually hold weight. And that is something that is food for thought. And it's a question, of course, to determine. But also, we could also argue in terms of evidence that might include perhaps recorded communications, testimonies, for example, or financial transactions that are linked to rebellion or even subversive activities. That is something, again, you may want to think about as food for thought in terms of the probability and chances of success. And also, we could also argue in terms of what they call political and judicial influence, which, in my opinion, becomes a very, very fundamental aspect here. Now, Uganda's judiciary has actually in the past been accused of favoring the state in terms of political sensitive cases. Yes. So if the court, for example, leans towards the government, then besigye may actually face an uphill battle even with weak evidence. And this is something that, again, you need to comprehend in light of the discussion that we're having today. Now, in terms of another argument that you may want to comprehend is in terms of what they call the precedent of opposition prosecution. Yes, which is substantially important. Now, also, we could also argue that previous opposition leaders in Uganda, including, besigye himself, have actually faced treason or even similar charges, often resulting in prolonged legal battles rather than outright acquittals. And that is something, again, you have to comprehend in light of the discussion that we're having today. So, my friend, this discussion is not just as simple as that. The state might actually drag the case, to keep him detracted from maybe a political activism rather than necessarily securing a conviction. So that is food for thought. And that also perhaps lays bare in terms of the gravity and the certainty in terms of the probability of success in terms of what would happen. Now, the factors that could probably lead to the acquittal in light of besigye's defense could be the following in terms of dispensation, because I'd like to be fair on the other side as well, not only to be on one side. I would like to argue and say in terms of a weak or even circumstantial evidence, if there is a weak or even circumstantial evidence in light of this particular treason, the treason may be difficult to prove because it requires concrete actions beyond mere political opposition. And these are things that you must prove. It's not just a question of hearsay. They have the concrete evidence. And then if the state relies only on statements, for example, associated with with certain groups or public speeches, then the case might actually be too weak to sustain a conviction. And that is something you have to look at as well. And then the argument of previous failed treason cases against besigye also shed light in terms of the weakness of this case. Someone could say this is a witch hunt against this individual. We could argue, for example, in 2005, besigye was actually charged with treason, but the case collapsed due to lack of evidence. So there's a possibility that maybe this is a ghost that is haunting him in light of that particular dispensation, if you like. So the courts may view this as a new case with skepticism, okay, especially if it appears politically motivated rather than legally what? Justifiable. And this is something that you must understand when you are making a decipher in terms of the suggestibility or the probability of success in as far as this besigye case is concerned. And then you could also argue in terms of international and public pressure. Yeah, there is substantially a question of international and public pressure. That is something you must understand. Given Besigye's status as a prominent opposition leader, there is no doubt that his prosecution could actually draw international criticism, and that is subjective in the sense that many people who ordinarily would not want or who are probably a little bit tired in light of the government would say, wait a minute, I think this is persecution. So the case gains global attention. Uganda's judicial system may actually face pressure to ensure fairness and potentially reducing the charges of conviction. And this is substantially very important in light of the discussion. And then the legal technicalities and the rights violations, can also come into play. That is substantially important. You could also argue in the sense that if Besigye, for example, his arrest, detention, and trial procedure violated constitutional rights, for example, unlawful detention, or even torture, or even the legal team could actually argue for dismissal on procedural grounds. So these are substantial issues that could also come into play. So when you are looking at this, don't look at it on the face value of it. It goes more than what meets the eye. And this is very important. So the shift, in my opinion, from the military to the civilian court could also be exposed the inconsistency in the state's case, weakening its credibility. I know there are struggles and scrambles in as far as trying to, to bring it up in terms of the civilian court because of the Supreme Court intercession, but then that's another question. Now, what are the possible outcomes? Some of the possible outcomes could be the following. For example, number one, there could be, in light of what are the chances of success, I could argue, in my opinion, that given the tendency of the test, that if the state, for example, has a strong evidence, a conviction is possible, but unlikely given the history of similar cases. And that is substantially something that is extremely important for you as a take-home in light of the discussion we're having today. So if evidence is weak, Besigye's legal team would actually push for a dismissal or even for an acquittal. And that is substantially important for you to comprehend in light of the discussion that we're having today. And lastly, but not least, I would like to argue and say the most realistic scenario is that, is that the case drags on without clear resolution, serving a political tool to limit his activities. And that's something that, again, we may want to think about as food for thought. And this is something that really strikes us as jurists and as constitutionalists in terms of trying to comprehend. And the argument is that the case is more, in my opinion, perhaps about political containment than legal justice, making conviction unlikely but not impossible. And these are things we need to think about even as we begin to debate on the probability or the ability or the possibility of the conviction of Dr. Kiiza Besigye in light of the upcoming charges that are before him today. Once again, my name is Isaac Christopher Lubogo. Thank you for listening to me, and God bless you. Thank you for your attention.